Good morning, good afternoon, good evening. I am Jason Weiss. I am the host of the Ask Jason Weiss show that is on the home of goingboldmedia.com. Although I am an attorney, and although I am a coach, and although my guest today is an attorney, nothing we talk about here today is legal advice. You have not retained either one of us. There is no attorney-client privilege. And whatever we say is just general talking about the legal practice and generalities, and nothing should be relied upon. However, with that being said, if you have interest to what Andrew talks about today, you should contact him directly to talk about it. So I am going to introduce Andrew Schneiderman, who is on with me today. I've known Andrew for a handful of years now, and we met while practicing and handling a case together in the TCPA world. And I'm not going to do a spoiler here. Andrew will talk about what the TCPA world means, but he is someone that handles TCPA cases, class action cases, and all the types of cases that I can't handle as a solo here in Florida. So, and I will explain that in a minute, but without any further ado, Andrew Schneiderman of O'Hagan Meyer, and he's an attorney and an advisor. So, Andrew, say hello.
Hi, guys. It's nice to meet everyone virtually. So like Jason was saying, I do a lot of class action work. A lot of it's in the TCPA context. So let me back up a little bit. So when I say,
let me say something first. Andrew, for me and my clients, is a phenomenal resource. And why can I say that? I'm a solo practitioner. As many of you have met, I have one gentleman that works with me. We work together. But we're both licensed here in Florida and DC only. And I have clients that are all over the United States. And I got a phone call from a client, and we're just going to call him Mike for argument's sake. And Mike called me up and said, hey, we just got sued in Baltimore. Jason, can you help us? No, that would be unauthorized practice of law for me. But what I was able to do is pick up the phone and say, hey, Andrew, I know you might not be licensed in Baltimore, but I see you have offices in 14, 15 states. Can you help out? And I've done that with Andrew, and I've done that with, I've done that with Mike. I've done that with Mary. I've done that with Christine. I've done that with Chris. I've done that. And that's how it is. And, you know, Andrew and I work well together. We don't step on each other's toes. And one of the things the clients always ask me after that phone call is, well, if Andrew's doing the work and you're doing the work, are you double billing me? And the answer is no. Andrew bills for his work. I bill for mine. And there's no overlap because we work together. So that being said, Andrew is a go-to guy of mine in the TCPA world. Andrew, will you just start by telling people what the TCPA is?
You got it. So the TCPA, the Telephone Consumer Protection Act, is basically a series of regulations that govern when and how telemarketers, generally speaking, may place calls to consumers. And so it establishes a series of regulations governing the use of what's called auto dialers, which are machines which can place calls to telephones automatically. The use of pre-recorded messages.
What is a pre-recorded message?
So in other words, a pre-recorded message is a call that you'll receive, and then when you pick up the phone, it'll be just a robotic message saying, hey, please wait for the next call, or it'll be saying, hey, you know, donate X amount of dollars to this company. It could be a variety of things. So that's a pre-recorded message that that the TCPA governs.
So just out of curiosity, for my own sake and the listeners as well, what about the ones where it rings and you pick up and then like you hear like a dead air for, I don't know, 5 seconds, 7 seconds, 3 seconds, and then you hear the boop, hi, my name is, you know, Mary, and I'm calling you from, you know, ABC Corp. What is that?
So when calls are like that, that could be an indication that an auto dialer is being used. So that's oftentimes a plaintiff will plead that, just like you said, that she picked up a phone call, there was nothing but dead air, and followed by a robotic voice or followed by an actual person. That'll be an indication that an auto dialer is used.
Okay, so let's take a step back, because for some people that are not lawyers or attorneys, and we want to give them the benefit of the doubt, you said plaintiff. What is a plaintiff?
So a plaintiff here is going to be a consumer who was called by the entity in question.
Gotcha. Okay, so you got a plaintiff who's and in other words, it's the person that brings the lawsuit, right? It's the one that files the lawsuit. Oh my God, you called my phone and I've been damaged, and we hear that all the time,
and we get that all the time. Correct,
all the time. And part of the things is maybe back in 2010. I could see that, because I remember, we were all paying for minutes and we got the plans. And I remember, my wife and I were like, hey, we didn't use them this month. We can roll them into next. But now almost every person on the planet has prepaid for unlimited. So where's the damage, I guess, is what I'm still scratching my head about.
Yeah, it's interesting. It depends on really the jurisdiction that you're in. However, generally speaking, the call in and of itself is an actionable violation. You don't really need to show the damages that you're speaking of. Oftentimes, the courts have held that just the call itself will be sufficient to show that there are statutory damages which can be awarded, and therefore there's an actionable claim.
And so let's just say, hypothetically, I get a phone call and I find out it's from a company I've never heard of. I didn't sign up. I didn't say, please call me. I didn't fill out a form. I get a phone call, right? So then what happens? I call one of the, I either do it by myself or I call a lawyer. What kind of damages, does the plaintiff usually ask for?
So a plaintiff can get, let's talk about an individual case for a second.
Yep, just me.
So just you, a plaintiff can get $500 for each call that was made that violates the statute, or $1,500 if you can prove that it was a willful violation. And when I say willful violation, that you place the call knowing that the plaintiff or the consumer had asked you to stop placing the calls. They can be inferred.
So here's the thing that I hear, and I defend these cases just like Andrew does. He does it on a much wider area. He does it in more jurisdictions and more states and a much larger practice than I do. But I use this argument all the time. I say to the person on the other end of the phone, for my client to call you, it costs my client money. The actual person that's making the phone call, the actual person that's sitting there and taking down the order. They charge your credit card, and then there's a chargeback because you get your refund and all of that. So that one phone call, and probably the salesperson that made the sale gets some sort of commission on it no matter what. So that one phone call could cost my client hard costs. I don't know, $50, $75, $100, $200, right? So why would my client want to call you, sir or ma'am? They don't want to call you. They just happen to get your information. And if you would say no, thank you, that's it. Is there like, as a golf term, is there a mulligan, or is there a do-over, or is there a, do you get a free crack at the apple?
Yeah. So oftentimes if a plaintiff calls and says, do not call me again, you have a reasonable amount of time under the federal statutes to stop making those calls. Now, what constitutes reasonable? I believe the FCC had said, or the statute itself says 30 days max.
Correct.
And there's a reasonable amount of time, and the courts have not decided affirmatively what constitutes a reasonable amount of time. However, there is at least one decision which says that 1 day is a reasonable amount of time.
I will tell you this: the plaintiffs' attorneys that do this type of work, that know what they're doing, and ladies and gentlemen who are listening, you know who you are. They will usually abide by that 30-day time period. So meaning, if you called me today and it's January 11 and said, Jason, don't ever call me again on the TCPA, I'd probably have until February 10th to make sure that doesn't happen, right? Correct. It could have been an automated, it could have, done all that. Now, there are so many nuances about that. One of the things is, well, what about if it's, a company, right? Let's just say I have my TV service with Xfinity, right? Or Comcast. Let's just use Comcast. I have my TV service with Comcast, and I get a phone call from Comcast. Yes, can I speak to Jason Weiss? This is him. Hi, my name is Mary from Comcast, and we see that you're a customer, and we see you have package, the silver package, and we're running a promotion today to promote you to the gold package. You know what, Mary, I don't want it anymore, and don't call me anymore. And I hang up the phone. Is that a violation?
That would not be a violation. And let me tell you why. There's something called an established business relationship. So if the consumer has an established business relationship with the entity like you were describing, in other words, if you had cable, or if, with Dish Network, DirecTV, if you had your phone service through AT&T, you have an established business relationship with them. They can call you regarding.
Now, is there a way, Andrew, move your head to the side? You got this. There you go. You had the sun.
I'm facing, because I have two screens up. Sorry.
You had the sun coming in, and it was all that. So an established business relationship. So that's basically, just putting it in layman's terms for the dingalings like myself. If you have a subscription with Zephyr Hills Water and they're calling you with a promotion, that's not a TCPA violation.
Correct.
If you've purchased, a phone through Apple and they call you because your Apple Care is running out, that's not a violation.
Right. And that established business relationship runs until the consumer says, do not call me again.
Correct. Now, I don't know the answer to this, and you might not either. What happens if I want to keep my affiliation and my business relationship with Comcast, right? I want to keep it, but I don't want phone calls anymore. If I am a customer but don't want to be called, is that okay?
That's a good question.
Now, I know for a fact when I sign up for things like I was just part of like a course about TEDx talks, right? How to book them, how to get them, how to do all that. And at the bottom, it asked for my information. So I put in my name, I put in Jason at askjasonweiss.com, and it said phone number. And then it said, click here if you do not want to be called. So I put in I tried skipping it and it wouldn't allow me. So I put in my phone number for my office and I clicked that thing. They're not calling me anymore. They're doing everything through email. So I think that's a way around it, but I don't know if, and I don't have the answer. I'm curious, what happens if I have a business relationship with Comcast? I ask them not to call me and they call me anyway. I wonder what
I would suggest that under those facts that you couldn't call the consumer anymore despite the existence of an ongoing business relationship, because you've essentially withdrawn your ability to be called.
And I think that's the prudent and safest. So if any
Right,
businesses
I think
are out
that's
there
right.
listening, if they tell you don't call me, don't call.
Don't call.
You know, you could. Now, are there restrictions on text messages?
Text messages constitute, for the most part, will be considered calls as well.
Correct. I tell my clients treat the text messaging platform, the SMS, the exact same way you treat the
100%,
phone.
exactly, because they're functionally equivalent for the most part.
What about emails? Because I have, believe it or not, I'm probably one of the only people on the planet that still has an America Online account, an AOL. And when I go in there once a week to clean it up, I have hundreds, if not thousands, of emails about seamless gutters, replacement of windows, car insurance, burial insurance. Are they allowed to just hit my email as much as they want?
That's a good question. That's
why I asked it, dude.
I'm not sure about under the TCPA if it reaches emails.
I don't believe it does.
I don't believe it does either, but that's something I think that's a point.
But again, to all the listeners out there, although we're lawyers, this is not legal advice, so don't take it. But to business owners, the gist of it is be careful who you call, and don't call people that don't actively say they want to be called.
Correct.
If someone tells you, please don't call me anymore, or don't call me anymore, or leave me alone, or text back the word stop, listen to them.
Correct. That's the most prudent course of action.
And make sure that you stop it within 24 hours if that's reasonable. And if it's not, stop it by the end of the calendar month or within 30 days.
Correct.
And those are kind of like your safe parameters.
Right.
One of the other questions that I wanted to ask completely just escaped my mind. So I'll ask you a different question having to do with, again, on the TCPA. So how do you know if you can, oh, that's what it was. The DNC list. DNC is the do not call. Every once in a while, especially if you're in the area where we practice, you hear about the DNC. What is the DNC? How do you go about registering? And what are the benefits of the DNC?
Okay, so the DNC is, as you said, is a national do not call list. And what you are required to do is personally register your number on the do not call list. And if calls thereafter are made to you while your name is not on the do not call list, that could constitute a violation of the TCPA.
And I'm pretty sure there's that 30-day window that applies. So if you go on today, January 11, which is my book release day, January 11, go find my book, Shit They Never Taught You in Law School. It's on Amazon. If you want to buy it within the next 45 minutes because it's noon or 12:15, it's on Kindle right now for a great price, and then it'll be normal price and everything. But go buy it. Putting that aside, if I go on the DNC today and I list my number, there's 31 days in January. So by February 10, I should not be receiving phone calls.
That's correct. Otherwise, generally speaking, there could be a violation.
And that violation usually turns into someone making a demand for money. Correct. And a lot of times it will turn into the word that you just said, a class action. Right. Now, we hear about class actions all of the time. As a professor who used to teach law, it's not an action that we take in class together. What is a class action when we hear about it in the news and we hear about it all the time? What is a class action?
All right. So very generally, a class action is a claim that's brought by someone called a class representative, who's the plaintiff, on behalf of a group of persons who have
similarly situated
and who have experienced, and what I'm trying to say is who have experienced the same violation as the plaintiff has.
Correct. So you probably couldn't say hypothetically that people that got phone calls from an auto warranty, a home insurance, a car insurance, a solar panel company, a whatever, that they're all in the same class. But you could put all of the people that got from auto insurance in a class.
Correct.
Is there a certain number of people? Like, do you need 4 or do you need 30?
So basically, generally speaking, you need about 40 people to constitute a class. That's generally what the federal courts require.
And I know you don't do plaintiff side, correct? You do primarily defense side. So you read about them all the time, right? I read about a class action the other day, and it was like, I actually got something on my phone the other day that if you did a certain thing with the iPhone and it was slowing down, and Apple, that, you know, there's a huge class that just settled. Or actually the transactions on credit card fees with Visa, MasterCard, Amex, there's a class action out there, right? So I took credit cards. I got the class action notification card in the mail. So I'm probably in line for millions of dollars, right? Because, you know, the class just settled for, you know, 480 million. So I should probably get, you know, millions of that, right?
Well, it doesn't work like that. So what happens is,
what do you mean it doesn't work like that?
Each class member gets
explain me.
Each class member gets a pro rata portion of the total amount of money that is awarded to the class. And so what you can do when you receive those notices is either just stay in the class, receive your share of the amount of money that's awarded to the class, or you can opt out. And then if you were to what's called opt out, then you would go to court and say, I don't agree with the settlement. For whatever reason, I would like to pursue the claim individually.
And then the court has discretion, or what does the court do in a situation like that?
The court has, my understanding of the court can hear not the individual class representative's claim.
Right. So I'm going to give you the perfect example. I'm just going to cover up, you know, some personal stuff, but I got this in the mail literally yesterday. And it's a legal notice. It's Armstrong versus Kimberly Clark Corp., case number 20-CV3150, Circuit Court for Northern District of Texas. If you purchased any types of Cottonelle flushable wipes between February 7 and December 31st, 2020, in the United States, you may be eligible for a cash payment for a class action settlement. So I got this in the mail. So what do? Well, like Andrew just said, if I do nothing, then according to the rules and what's written on the back, if I submit a claim form to be eligible for a cash payment, you have to have a valid claim form no later than January 16. You have to do all this kind of stuff, right? So that would include me in the class. So if the class settles for $1 million and I bought one pack, I'm going to get a small portion of that, and I'll probably get 27 cents. Now, what about the lawyers that bring those cases? I'm sure they're not getting 27 cents, right?
No, lawyers are getting a third of the settlement. And normally what happens is that in order to obtain an award, it has to be approved by the court.
Right. And a third, where Andrew said that it's all going to vary from state to state to state. Because I know, and I'm not a class action attorney, I don't do that, and I don't do many cases on contingency, but the Florida bar has a form that you must attach to your retainer letter, and it lays out if it's $0 to $1 million, you're allowed to take like 33% of a pre-suit and up to 40% of something once you file it. From $1 million to another, the percentages are laid out. So make sure, ladies and gentlemen, that when you do retain these plaintiffs' attorneys, that you read the retainer letter and you're presented with it, because you want to know what you're getting. Because there are cases that I have heard about where, you know, the defendant will pay a lot of money and each class rep or each person makes minimal to nothing. I think it was, wasn't it in that book, a civil action by the John Travolta was in it. It was a Grisham movie.
Jan Schlickman.
Yeah. I think it was the whole thing where, you know, the lawyers wound up making tons and tons and tons of money, but each person in the class that was affected, they only made a little bit. Same thing in the Aaron Brockovich movie. It's the same thing. So just be careful what you sign up for. And oftentimes it's people get in a difficult spot. It's, hey, have an attorney review your retainer letter with your attorney. And then what? Have another attorney review that and do. So it's always in there. Just my one piece of advice is make sure you understand what you're signing. That's the most important thing. And if you don't understand it, don't sign it.
I think to add on to that, from the other standpoint, the defense standpoint, it oftentimes makes sense to try and maybe I'm getting ahead of myself, to request a copy of the plaintiff's fee agreement in discovery, because you never know what it's going to say. And if it doesn't comply with the ethical obligations, there's a disqualification argument that can be made. And we've made that argument in the past before.
And that's all important. Again, you need to know your rights. You need to know what you're entitled to. You need to know what you're giving up. You need to know what you're signing. Because look, I've had it in the past where, we've settled a class or we've settled an individual, and then 6 months later, I get a demand letter from another attorney for the same person. It's like, no, you waived this,
right?
And that attorney will say, oh my God, I didn't know this. Or the plaintiff will say, I didn't know what I signed. So you need to be on top of your game, because in class action cases, you're talking about a lot of money, potentially a lot of money.
Especially in the TCPA, where there's no cap on the amount of damages, which may be awarded, as in when you compare it with the Fair Debt Collection Practices Act, which is a similar Consumer Protection Act. That act has a cap on the amount of damages which can be awarded to the plaintiff. The TCPA doesn't, which is why it's very dangerous.
Gotcha. So it's basically, and again, who and this is not a judgment. This is just some insight. In these TCPA cases, who makes the money? It's usually the lawyers, right?
Usually the lawyers.
I mean, you get a lot of these very sophisticated plaintiffs that know what they're doing, that represent themselves, and they will make a majority, if not all, of the money. And when I say it that way, because sometimes there's people out there helping, and they keep it hidden, and that's a whole new ball of wax that we're not even going to get into. But at the end of the day, these TCPA and class actions as a whole, it's usually the lawyers that are making the money.
Correct.
And you hear about it all the time. You see the advertisements. And I'm not going to single out this individual, but there is a gentleman on Instagram, of all platforms, that he's been putting posts up there that say, have you gotten phone calls? I can get you $1,500. Have you gotten texts? I can get you $1,500. They do it all the time. They'll get you the $1,500, but you might want to ask the attorney that's doing it, hey, what do you get out of it?
Right.
They're going to tell you 50,000. Wait, you're going to get 50 grand and I'm going to get 1,500? Really? Just know your rights, ladies and gentlemen. That's all we have to say. And again, we're biased, right? We want to help the companies. We want to help the people that make the phone calls. But at the same time, that's not the only area of law that Andrew practices. He'll defend cases, he'll help cases. He's done what? Construction defect,
employment, professional malpractice, you name it.
Now, we met, I think, were you living in Florida when we met, or were you already up north?
I was already up north.
So you're already up north, but we're both Florida guys. So without getting overly personal, what dragged you from Florida up to the Northeast where you're at now?
My ex-wife was from Massachusetts.
Gotcha.
And wanted to be close to her mother. And so we moved up to Massachusetts from Florida. And then ironically, her mother moved back to Florida. So go figure.
Yeah, well, and you're a proud daddy. You got kids.
2 kids, 14 and 12.
and you enjoy every second of it. We actually, Andrew and I, were lucky enough to grab some coffee a couple of weeks ago here in South Florida. I've got my two kids. I talk about them all the time, 17 and 14, and that's that. And we're going to be coming up to Mass hopefully in the next 45 days because Logan's going to go check out a school or two. So we're excited for that. What is your one piece of advice that you would give to large business owners, small business owners, any type of business owner to protect themselves other than, hey, call Andrew and know what to do beforehand? If they want to be like, hey, look, what's one piece of advice you could give me? So what's one piece of advice you can give in the TCPA world?
I think, the best practices is that I think we stated it earlier. If someone says, do not call me, don't call them again.
And again, it doesn't need to be a specific word stop, or can you please not call me? Or I don't know. Do courts say if you call and say, hi, I'm Mary calling from ABC Corp, and they hang up on you? Is that
right? I'm actually dealing with that issue now. So I take the position that if they hang up or they say it's just a wrong number, that's not necessarily a statement to stop calling. You need to affirmatively state it. Now, that being said, I think that might be a little bit of a stretch, but it's a position that, we want to take to defend our client. I would have policies in place. I think it's important to have internal policies in place, even an internal do not call list. And just make sure you follow the policies. And that's really all you can do.
And if you don't know how to draft your policies or you don't know what should be in your policies, you should call someone like Andrew.
Right. And we can work together.
Hey, we need some guidance. We need some things. And Andrew can say, great. One of the questions that was just asked of us, is that the same for texting?
Yeah. So texting, like I said earlier, is fundamentally equivalent under the TCPA for the most part with calls, and that's a recent development. But texting is going to be on par with calls. So if someone says "don't call me" and then you send them a text message, that's going to be an actionable violation for the most part.
Correct. And also, ladies, gentlemen, and members of the jury, please remember that when you go places and you sign up, chances are you're signing up to get contacted by phone, by email, by text. Look, I went to my eye doctor, phenomenal eye doctor, very, very happy with him. And I ordered a 6-month supply of contacts. So guess what happened on month 5? I got a text from them saying, hey, you have a 6-month supply. Do you need us to order more for you? And I wrote, thankfully, yes, please order more. That was great. That was an invited text that when I signed up, I checked the box saying you could do it. So you need to be careful what you sign up for. I don't think you can go and join a Facebook page and just all of a sudden, because you joined a Facebook page, you're opting in to be called by every person on the planet, right? But if the Facebook page is for the Gray Sweatshirt Club, like Andrew and I are members of, and I can get text messages from the Gray Sweatshirt Club, I do not think, unless it specifically says, that I can get solicitations from the Blue T-Shirt Club. Is that correct?
Well, partially. So okay. A lot of the times what it'll say, you'll go on a website and you'll check and it'll require you to check a box. And under that box, it may say, by checking this box, you consent to receiving calls from us. And oftentimes it'll say, and our marketing partners. And the marketing partners will be a term that's in a hyperlink. And if you click on that marketing partners, it'll lead you to a list of partners whom you agree to receive calls from by checking that box. Now, do consumers do that all the time? No. And that really is the impetus for a lot of their lawsuits, because they receive a call from XYZ company, but they only signed on to receive communications they thought from the Gray Sweatshirt Club. So that's just something to consider when, looking at these cases.
Correct. And when you are a business, make sure that, you list who you're affiliated with and all of that. And when you're a consumer, know who their affiliates are. And again, it needs to be said. It can't just say, and any of our marketing partners. And then I say, okay, these 15 billion companies are our marketing partners. That's not going to fly. But if I say marketing partners and I list the 17 that are my marketing, and you get a call from one of those 17, you've consented to that.
Yeah, you consented to that. So it's good to know from both perspectives who the marketing partners are. And I think if a client website is going to do a hyperlink like that, you got to make sure that it's set off from the rest of the consent, so that it's obvious, it's open, a consumer can see it, and it's not a hidden component of their consent.
And just for curiosity, because someone asked me, these types of cards that you get in the mail, there's no action on that, right? You get it, it's paid for, it's postage paid. There's no action for how'd you get my name, how'd you get my number, why is it in there? Nope, it's there. So that's not something that you can take action on. So we're getting to the point. I can't believe we're almost done talking about the TCPA. There's so much more that we could talk about, and we can go on forever and ever and ever. You could get through to Andrew directly, for those of you that are listening, at 617-843-6808, or you could get him at A Schneiderman at O'HaganMeyer.com. And you can always just Google him. You can find him on wherever, LinkedIn and everywhere else. Business litigator. They're licensed in a ton of jurisdictions throughout the United States. So if you ever need a co-counsel, look no further. This is your guy. So Andrew, I usually end the show with, one of my toughest questions out there. So I guess one of my toughest questions out there would be for any law school student or someone thinking about going to law school, is there an area of the law that you see as picking up as like, yeah, this is an area that if I had a chance to go back and focus my area, I would focus it in?
Well, that's a good question. I mean, it really depends on what you're into. I mean, this area of law that we're in is exploding. I mean, the number of lawsuits that you see in consumer litigation is just getting greater by the day, So, but I mean, it really depends on what you're into. If you're into criminal work, start with.
So if you're a criminal, go to criminal law. If you're a civil person, go to civil. No, I'm kidding. But I mean, is there?
No, I mean, I would just. I don't know that you choose the area of law so much as it chooses you. Is really, like, for example, with this area of law, I fell into it because one of my partners didn't want to do it anymore.
Man.
And so I said, hey, I'll do it. And that was 15, 20 years ago. And then I've been doing it ever since.
And I fell into sports and entertainment law because I was in sports authority. That lets you know how long ago I started sports law. And there was a celebrity and former boxer there, and he signed some gloves for me. And next thing you know, it was my first sports and entertainment.
Yeah, so I think it's what you fall into as opposed to what you choose.
And follow the passion. If you love art, then do something in entertainment. If you love building and construction, go do construction law. If you like, helping people that were, wrongly accused, then do civil rights stuff. So, and I talk about that. Here's my self plug in my book, Ask Jay, the shit they never taught you in law school, the survival guide to navigating the law, which you can get on Amazon right now. And if you tell me that you purchased it as a result of this show, I will make sure that you are taken care of. So, Andrew, I thank you for being here.
Thanks for having me.
I thank you for allowing me to wear a gray sweatshirt because I know that is your that is your thing. I look forward to working with you again on cases. And again, ladies, gentlemen, and potential jurors, got any questions? TCPA, marketing, litigation in general, where to go eat in Massachusetts or Florida? Reach out to Andrew. His information is there, and you can always find him on O'HaganMeyer.com, and it's AskChneiderman at O'HaganMeyer.com. Andrew, thank you for being you.
Thanks for having me,
Joe, and thanks for doing all the great work. I love working with you.
Yeah, it's been great.
Cece, as always, thank you for putting this together. You are awesome. Home of GoingBoldMedia.com, and I look forward to seeing you all in 2 weeks. Have a great